All right. Well, good morning, everyone, and thank you for joining us today. So, my name is Billy Doherty, and I'm the president of Doherty Staffing and Dahl Consulting. So, we specialize in helping businesses like yours stay agile, compliant, and fully staffed in this fast-changing labor environment, with our services spanning light industrial, manufacturing, professional, managed services, and IT. So today we've got a very impactful topic to discuss, and I'm joined by Melissa Jaden, our senior HR manager here at Doherty and Dahl, and also joined by Leah Elliott. She's the co-managing partner at Staffing GC, which is an outside legal firm that supports companies across the staffing and recruiting industry. Today's webinar is focused on the Minnesota Paid Family and Medical Leave Act, which is a major new law that will take effect on January 1st of 2026, and one that has already been raising important questions for employers across all industries. As someone who works closely with organizations navigating workforce challenges, we wanted to bring you this session to help you understand what's coming, how it may affect your employment strategy, and why your planning for this upcoming change should be well underway. Under this new law, Minnesota will become the 13th state to operate a statewide paid family and medical leave program. So eligible Minnesota workers will have access to up to 20 weeks of paid leave per year for their own medical needs, or bonding with a new child, or caring for a family member. It's a big step forward, but it also presents a real need for employers to build flexibility into their teams, especially when it comes to covering extended absences. That's where temporary staffing and contract labor can play a critical role. During today's session, we'll briefly walk through the key components of the law, including how it's funded, who qualifies, and what employers can expect, and how contingent labor can help in the face of longer and more frequent employee leaves. Whether you're a current client or exploring your options, I hope this session gives you valuable insight and a few proactive ways to stay ahead of what's coming. So with that, I'd like to hand the presentation off to Melissa J.
Good morning, everyone. Thank you for joining us. Paid leave has been a hot topic over the last couple of years. It went into legislation in 2023, and now the time has arrived for us as employers and HR practitioners to prepare for Minnesota paid leave. So effective January 1st, 2026, all employers in Minnesota, regardless of size, if you have one employee or you have thousands of employees, this is a requirement of all employers, including those of you who may be 501c3 nonprofits, religious entities. This applies to everyone with the exception of 1099 employees who are true contract employees. Contractors can opt into the Minnesota paid leave program. So if you're 1099, you would need to go through the state to opt into the paid leave program. But again, all employers are required to participate. The purpose of the Minnesota paid leave program is that it provides partial wage replacement and job protections to employees who may need time off away from work for their own health care or the care of their family members. Who qualifies for paid leave? So the list on who qualifies is really anybody who is employed with your organization. So this includes your part-time employees, your seasonal employees, your temporary workers. And there really is no age requirement on those part-time employees. So if you have an employee who's working for you that's 18, 16 years old, this also applies to them as well. Again, self-employed individuals may opt into the state plan. Again, they would need to go out to the state website and fill out the application and the information to enroll as a participant in the paid leave plan. Employees who live outside of the state but spend 50% or more of their time physically working in Minnesota are eligible to participate in the paid leave plan. So for employers that do have employees in other states, if your employee is spending 50% of their time physically in Minnesota, they are eligible for paid leave. Employees who earn at least $3,900 in the last year are eligible to participate. Now that dollar amount will increase year over year. This is the dollar amount that an employee needs to earn for 2026 to be eligible for the plan. And the qualifying event must last at least 7 days. That is not 7 consecutive days, but 7 days. 7 days throughout the month, however that works out, but it is not consecutive days. The types of leave available, so there are two different buckets within the state plan. There's the medical leave bucket and there's the family leave. So to qualify for the medical leave, this is related to an employee's own serious health condition that prevents them from working. And this also includes childbirth, conditions related to pregnancy or surgery. So very similar to what we see with FMLA. If you're familiar with FMLA, this mirrors what that looks like. Now, the family leave is a little bit different where there's some additional options that FMLA does not offer. There's bonding, and this is for the birth of a child, adoption, foster care placement, anything related to a child being placed in the home. Caring leave, this is for employees to be out to care for a family member who has a serious health condition. Then there's military family leave, and then safe leave. The safe leave is very similar to what ESST offers, where it is for domestic violence, anything where they're caring for somebody that might be involved in a domestic violence situation, having to go appear in court for a lengthy period of time, safety of an individual or a family member. Next slide. So who is considered a family member? So similar to ESST, as many of you on this call are probably familiar, is that ESST really encompasses anyone. Paid family leave is very similar to that. A spouse or partner is considered a family member. Child, whether that is biological, adopted, step, foster, or a child that an employee has raised, even if they are not legally related. Parent or person who raised you, sibling, grandchild or grandparent, in-laws, including son, daughter, father, or mother-in-law, and then anyone close to you who depends on you like family, even if they are not blood related. So again, very similar to ESST, where it's really anyone could be considered that family member. As far as the benefits goes, we'll discuss a little bit later about the tax component, but the state is looking at these as two separate buckets. So the leave time that an employee will receive in a single calendar year is 12 weeks for medical and 12 weeks for family leave. But an employee can take combined maximum of 20 weeks in one benefit year, so combined between the medical leave and the family leave. The employee's benefits starts the first day that you have the option to pick how you look at that 1 year period under paid leave. But if you are using the state plan, they will be going off of the first date that the leave begins. Employers can set the time frame they expect to be notified. So best practice typically you see with FMLA is 30-day advance notice or as soon as practical. Really, recommendation would be to put some sort of parameter that you want to be notified within 30 days in advance so you can prepare your team, plan accordingly to support time that that person will be out of the office. Wage replacements, employees will receive between 55% and 90% of their regular wages while on leave, earning up to a maximum of $1,423 per week. The state currently has a different percentage of wage replacement through the state. Benefit protection. So this is different. It mirrors some of the standards as related to some of the state laws and federal with FMLA, but employee benefits must continue while the person is out on leave. And one thing that as employers, and we'll discuss this a little bit later, is determining how you're going to collect those benefit payments from that employee while they're out on leave and they're not receiving a paycheck from you. So again, you must continue to carry all benefits for that employee that you offer. And I will hand it over to Leah to talk a little bit about some protections and some other matters of compliance related to this law.
Sure. Thank you, Melissa. And good morning, everyone. Thank you for joining us today. Very important topic, lots of changes, and hopefully this is a little bit of a refresher for most folks. And if it's something you've not dealt with or started, to create your accounts or preparing notices, reviewing policies, this will be a great way to start to develop that to-do list to get that knocked out in a timely fashion. One of the components of this Minnesota Paid Leave Act that's important, in addition to who's eligible, the payment itself, the fact that the leave is paid, is that there's also the component of job protection. So just like with FMLA and similar laws, they often include a component that also protects the employee's job and requires the employer to return them to the same or equivalent position. And they go on leave, then they are eligible to return into the same or equivalent position as if they had not taken leave at all, right? There's a corresponding that we often see anti-retaliation provision in there, which provides that employers are not permitted to retaliate against an employee for requesting leave or taking leave, obviously very similar to all other protected leave that employers interact and engage with. Retaliation is prohibited. Now, there is this concept of supplemental payments, which is interesting and a little bit unique for employers, and some decisions will need to be made in and around this space. And Melissa shared that, the employee is going to be receiving from the state, right? So this is a state administration. The employee applies through the state portal. The state makes the decision. The state issues the payments, right? They administer it very, very much like, I think of it running parallel with the unemployment system, because it's very similar in that regard, that you have this state as a third-party administrator here in the middle and funding and dealing with that. But one thing an employer can do is they can offer supplemental payments for your employees to top off the differential between what the state approves to pay for paid leave time and enough to make the employee whole. Because if they're only paying 60, if the state approves a 60% payment for that paid leave time, the employee can be offered the option to utilize a voluntary PTO benefit that you may offer, or employee sick safe time if it's ESST eligible. The reason has to be covered under that as well, right? To make up that gap in the take-home wages that they're bringing home and their compensation. But this is a decision point for employers. Employers will need to decide if they will or will not offer this opportunity to employees. But what employers cannot do is we cannot mandate that employees have exhausted PTO or employee sick safe time before tapping into this new Minnesota paid leave benefit. Right. So very important to be sure that the employee is making the decision. If they decide to use PTO instead of the paid leave, they can do that. If you allow them to top it off, they can do that. If they don't want to top it off, they don't have to. Right. But the employee really needs to be in the position of making the decision of which bank of leave they are pulling this from. So it differs from FMLA that way, which gives employers a little bit of flexibility and the opportunity to codify in its policies that, for FMLA purposes, you can often require, if you've reduced it to writing and provided notices and met all the compliance requirements, you could require employees to exhaust PTO. But for purposes of this Minnesota Paid Leave Act, that is not an option for this purpose. So you want to be sure that you're deciding first whether you will or will not allow your employees to top off that Minnesota paid leave benefit. Obviously, there's some administrative components that you'll want to think about and how you manage and handle that. And then adjust policies to make sure that you're clear that in training with managers to be sure that folks know that they can't require those employees to exhaust PTO or employee sick safe time. And then in terms of interaction with other leave benefits out there, so we talk about FMLA. Minnesota obviously has the Pregnancy and Prenatal Leave Act. There's Employee Sick Safe Time. what employers want and need to do is, if you want to try to minimize stacking of these benefits, meaning FMLA and Minnesota pregnancy parental and paid leave, and you end up with these stacked and you want them to run concurrently instead, is you have to look at your policies and make sure that the language is in there that makes clear that all leaves, where applicable, are going to run concurrently, right? So the best practice is going to be to run those leaves together so that you don't end up in a situation with, instead of someone missing a maximum cap of 20 weeks potentially under Minnesota paid leave, but then they add on another 12 weeks for unpaid FMLA, job protected leave. Right now you're looking at 32 weeks instead of 20, and maybe those could have run concurrently. But you have to proactively review your policies, make sure there's language that makes that clear that that's what's going to happen. And you are able, if the reasons qualify for both, for more than one leave category, for the most part, those can run concurrently. So make sure you're looking at your policies with your HR and legal advisors and make those adjustments as needed. And then on the paid, like, logistics itself here, right? So this is being funded, just like in the same fashion I mentioned it reminding me quite a bit of unemployment. It is being funded by a payroll tax on wages. And so the percentage of the premium on the payroll tax is 0.88 for non-small employers and 0.66 for the small employers. And as you can see at the bottom, we've got defined what small employers are. It's 30 or fewer employees, and their average wage is less than 150% of the statewide average weekly wage. For those who do qualify as a small employer, note that there are some grant opportunities available if you meet that definition that you might want to look into in terms of helping to minimize cost impacts. Several employers are obviously not going to meet the small employer definition, in which case they'll be responsible for withholding up to the 0.88%. The employer has to contribute at least 50% of that, and which obviously means that the most the employee can be required to contribute to that payroll tax premium is 50%. Now, an employer or an organization can decide to contribute more or all, but they can't go below that 50% threshold, right? And we're going to talk about this in a moment in terms of deadlines as well. But keep in mind that if you are planning to take a deduction from the employee's wages, whether 50% or less, whatever that number is, you must provide at least 30 days advanced written notice to the employee with respect to that deduction, which means that while January 1 is the go live date for this act and this benefit, you will have had to have successfully notified your employees of that wage deduction no later than December 1. So I strongly encourage folks not to push this off, much past Thanksgiving, to decide the premium contribution and then if and how you will be notifying employees of that wage deduction to make sure you're compliant with the wage and hour laws on deductions impacting your employees' wages. And then in terms of the plan options, Melissa mentioned that there's, the state fund and a private option type avenue you can go down. Most employers that I'm talking to in Minnesota, it feels like at least 85% are going through the state funded plan this first year. I don't know if that's a result of there not being much product on the market that maybe is marketing and competing for this type of business. But if you decide not to go through Minnesota's plan, there is an opportunity for you to develop and administer a private plan where you probably have a third-party administrator that you retain to handle the processing of this directly. But keep in mind, if that's the route you want to go, that you have to secure permission from the state. You have to submit what that plan is, submit the applications, receive the approval before that's considered a compliant plan under the law. So If you are going the private plan route, again, just like with making decisions about payroll tax premium contributions, you want to make sure that those decisions are made well in advance of January 1, because your application needs to be put in and the state will need time to review and respond to those petitions for anyone going the private plan route. So that's another reason why I just mentioned to make sure not to just get fixated on January 1. And I'll turn it to Melissa, who I know has a timeline, I think, coming up with a lot of these dates that'll help put that together. Oh, nope, I've got one more. There we go. One more before the timeline, almost. The premiums, just from the employee perspective, and no doubt, I think we can all expect that this is going to cause employee confusion. This is a brand new system. They have to go and apply on the state's website, right? You're not going to give them the application forms and review them and approve them and make the decision. That's all done through the state's portal. They've got to set up, their own access accounts to get in there. It's cumbersome. It's a little clunky, and it's new. But from the employee's perspective, in terms of taxes, premiums from the employee side, that if you decide that you're going to have the employee contribute some portion of that, will be assessed against post-tax wages. So that's one piece of it. And then the payment side, right? The actual paid leave benefit the employee receives. That tax treatment depends on which of the two buckets that Melissa referenced they're pulling the benefit from. If it's from family leave, that's not considered wages. The state's going to issue the 1099 to the individual at the end of the year, right? Done. You don't have to worry about that. Medical leave payments are, some portion of that will be subject to Social Security and Medicare taxes. Now, the employee will be asked at the time they apply for leave if they want the state to withhold those taxes from the paid sick leave benefit or not. The employee will be responsible for the taxes ultimately. And the state, at the end of within the timelines for issuing, with plenty of time for you to complete and issue the W-2s, right? The state will report to the employers what amount employers will need to populate into that box 14 on the employee's W-2 that is attributable to taxable medical leave payments that are going to be treated as ordinary income to that employee. So not that you need to get into the business of advising your folks on taxes, but just having a broad understanding, I think, is important to just sort of help Sherpa people through this process a little bit and help guide them towards, their tax advisors if they have more in-depth questions. And now I'll kick it to Melissa on deadlines.
Thank you, Leah. And as Leah mentioned, taxes and making sure W-2s are set up correctly and the payroll tax deduction. If you haven't done so already, I recommend that you start having conversations with whoever your payroll provider or HRIS system that you use, ensuring that you have everything set up from a tax premium deduction rate, W-2 set up for the go live of these deductions on January 1. So some key milestone dates, these really align with what the state of Minnesota is driving and the deadlines that they have set forth. So back in October of last year, which is already a year ago, I mean, at this point, we're less than 75 days away from January 1st. But back in October of 2024, employers should have started reporting their first quarterly wages. Wage reports were due. Now, don't worry if you're already sending this information over to the unemployment, you're already taken care of. If you are somebody who happens to fall into the category of being a religious organization, so your churches, some maybe smaller nonprofits that maybe are not registered with the unemployment portal or having to contribute to unemployment, please make sure you go out. It's not too late. Go out, get registered with the unemployment website, because that's going to be part of the steps in the process of getting access to the paid leave website. And we'll talk a little bit later about getting registered and what you need to do. But then you need to determine this year, and you're running up close to the deadline of whether the state plan or a private plan is going to be the best option for your organization. As Leah mentioned, she's hearing a lot of employers in Minnesota are going towards the state plan. One of the benefits of going with the state plan is that you should be in compliance with everything that the state is requiring because you're following through their process. But making sure that if you are opting to go through a state plan, you need to submit an application and have that approved by the state. That deadline is coming up quickly. It is November 1st. Now, this is a soft deadline. They will take applications through mid-November. However, to ensure that you're ready to go live on that January 1st date and everything has been approved, they have that November 1st deadline. July of this year, they did open up the portal for outreach for grant funds that are available for those smaller businesses. So if you are a smaller business and you're on this call, that is something that I encourage you to look into to see what is available to you. December 1, Leah mentioned this earlier, is the deadline to notify employees in writing of this paid leave program. If you are deducting any taxes from their paycheck, what that is that you're going to be deducting, what that amount, when they can expect it. January 1st is the date that the portal goes live. This is when employees can start applying and begin taking family leave. And they will retroactive, because I'm sure if they get a lot of applications on January 1st, it might take them a little while to approve those applications. They will make sure that that person is paid from the date that they begin their leave. And then April of 2026 is when employers pay their first quarterly premiums to the state of Minnesota. So right now, from January till April, the program is funded. The state set aside funding to support that pay, and that they will collect that first premium come April 2026. Now, one of the things that I've been hearing from different webinars that I've attended is there's that concern of timely payment for employees. We don't know what that's going to look like when the state program goes live as far as when they're going to receive payment. And unfortunately, if you're with the state plan, the employer isn't going to have a really a line of sight into any of that information. So the employee is going to need to reach out to the state if they have questions on their payments or anything related to approvals or with the benefits, because the employer just is not going to have line of sight. And as Leah mentioned, the employer doesn't make the decision in whether these leaves are approved or denied. Now we're going to share some examples with you of situations that might occur and how all of the time off leaves, whether it's a state or federal leave or Minnesota paid leave, how they all interact. So scenario one is you have an employee who has a baby on August 31st of this year, 2025. They used FMLA because they met the eligibility requirements and they've exhausted their 12 weeks. They used it unpaid. It was job protected because they had been with the organization for over a year and met the hour requirement under the FMLA law. They're eligible also for the Minnesota pregnancy and parental leave law, which is also 12 weeks of coverage. We talked a little bit, Leah touched on this, about making sure your policies run concurrently. So making sure that the Minnesota parental leave law runs concurrently with the FMLA law. So they exhausted that time. Then they have the eligibility to use PTO or ESST to top off any benefits. And come 2026, January 1st, because they had that baby in August of this year, they're eligible to take Minnesota paid leave for 12 weeks until the baby turns 1. So they would have until August 30th of 2026 to either request continuous bonding leave or intermittent leave to bond with their child, and it would be paid under the Minnesota paid leave law. Now, one thing with intermittent, as you're looking at your policies, under Minnesota paid leave, the state does allow for the employer to set the increment requirements for intermittent leave. So if you want to manage it similar to FMLA, where it's any time that the person needs, whether that's 15-minute increments or an hour, you can set that. You can also say, no, we want the person to take 4-hour increments or an entire day. You have the ability to set that. The state is allowing for employers to make the determination on intermittent leave if what increments it'll be used in. So next example, we have an employee who has been employed with the company for less than a year. They have a baby. One thing to note is, yes, there is job protection under the Minnesota State Leave after 90 days of employment. However, under Minnesota Paid Leave and the Minnesota Pregnancy and Parental Leave Act, they're eligible for the Minnesota Paid Leave benefit on day one. And under the Minnesota Pregnancy and Parental Leave Act, they have job protection on day one of employment. So keep that in mind when you're looking at these benefits. So this employee has worked for less than a year. They're not eligible for FMLA yet because they have not met the 1-year requirement and the 1,250 hours. Another thing to keep in mind is under the paid leave and FMLA, if you are looking at both of those benefits, FMLA has some different requirements than the paid leave program. So just make sure that you're looking at who's required under those plans. So they're eligible for job protection unpaid under the Minnesota Pregnancy and Parental Leave Act. They can request Minnesota paid leave, and they have up to 20 weeks that they can use because they can take the medical piece for having the baby, and then they can take the piece for bonding. So they can take up to 20 weeks to be out for leave for having a baby and it be paid. Now, they may not have the job protection if they haven't worked 90 days under the Minnesota paid leave, but they do have job protection, again, under the Minnesota Pregnancy and Parental Leave. Now I'm going to hand it over to Leah to talk about some more examples.
I did see a note pop into the chat that I just wanted to address real quickly around the earnings at 3,700 versus 3,900, and that is correct. It's the website says they have to have earned 3,700 in income to be eligible. But one thing to keep in mind around that, just as a quick little squirrel here, is that just like the employer is not deciding the benefit amount, you don't have to look back and decide if they've met the earnings thresholds. The state is going to look, and it doesn't just depend on how much they've earned from their current employer. They're going to look back a year and see how much they've earned the entirety of that 12-month look back period, right? So it's not contingent upon what they've earned for you. It's contingent. So it's going to be a broader swath of folks that are eligible. Pretty low threshold to clear. And this example just feeds off of the last one that Melissa provided. But in this scenario, we're saying this is someone who's been employed for more than a year with you, and is an example of the maternity and bonding leave and the interaction and interplay between the various buckets that folks might have time available for use, whether paid or unpaid, protected or not job protected. And so for someone who's been employed for more than a year, and assuming that they met the 1,250 in hours in the last immediately preceding 12 months, they will be eligible for 12 weeks of unpaid time under FMLA. That time is considered job protected. Under Minnesota Pregnancy and Parental Leave Act, likewise, they have eligibility for up to 12 weeks, also unpaid, job protected, just like FMLA. Want those to run concurrently, right? Because you don't want those stacking on top of each other. So very, very important that it be clear to employees that that type of stacking is not permitted. And then depending upon your PTO that you may voluntarily offer to your employees, and whether or not the reason is employee sick safe time eligible, and if you allow your employees to top off their Minnesota paid leave, they can potentially have access and use PTO and ESST to have access to that partially paid component to top off and close the gap between what Minnesota paid leave would pay and the 100% portion of their regular income. And then, of course, with Minnesota paid leave, they are eligible for up to 20 weeks, two different buckets. And it doesn't mean that they're automatically get 12 in one and 8 in the other. It might be that the medical, their own side is, 4 weeks, and then they take 12 weeks on the family side, or, it's a breakdown, but it's the maximum that someone can potentially qualify for is up to 20 weeks. That is paid because they've been employed for more than 90 days in this scenario. That also means that it's job protected. So they must be returned to the same or similar position as what they were in previously. And then another type of leave, which is not related to maternity or bonding, which has a little bit more complications because of the other laws that interact there. This is typical family and medical leave type scenario, which is if we assume an employee has been employed for at least 1 year, and they have two instances of situations in which they're accessing protected leave. And so assume at time 1, they need to be out to care for a sick family member recovering from surgery. And later they need to be out for their own serious health condition, right? So we're splitting between their own medical leave and then family leave. So under FMLA, they would be eligible because they're employed for more than 1 year. And again, assuming they meet the hours requirements, they're eligible for unpaid job protected time off for both, potentially, depending on, want to be sure that obviously you would go through your FMLA process, certify that the reason it qualifies as a serious health condition under the Family Medical Leave Act. The definition of a family member under FMLA is slightly more narrow than under state law. So, making sure that family side leave is eligible, assume they meet all those criteria. There's a potential for FMLA time to come into place here. Again, they have the PTO and employee sick safe time top off and kind of close the gap type options there. But again, keep in mind, you cannot require and mandate that the employee have exhausted those PTO and employee sick safe time benefits before accessing Minnesota paid leave. You can, for FMLA, if it's in your policy, if you have it written out, you notify employees accordingly and comply with the requirements there, but you cannot have that same exhaustion requirement apply to Minnesota paid leave. That component will provide your employee with up to 20 weeks. That will be paid. And again, because they've been employed for more than 90 days in this scenario, that is job protected time off. So lots of different ways. And truly, I know they're all in spreadsheets, but it really does feel like you have to develop kind of your own internal tracker that you run all these scenarios through, if and when someone comes to you. Now, you don't have to make the decisions on the Minnesota paid leave, but you do need to, once you know someone is taking that, you need to know how that's going to interact with your existing policies and banks to know what sort of, credits you need to give for, time that they've taken, and reduce those banks according to the policies that you put in place now. So a few key takeaways that I want to share. And the biggest one right now is really, communicating with your employees. I mean, this is like I said, it's clunky. It's just going to feel a little bit overwhelming to employees to some extent. And so making sure that your folks internally are trained up is important. Designating someone who can, maybe field those questions for you, kind of serve as the primary, point of contact or representative for questions employees may have, either in HR or benefits or employee relations, because there's going to be an awful lot of confusion here. The December 1 date is very important. You must notify your employees of this new law on or before December 1st of 2025. That's for your currently working employees, right? And then any employees hired thereafter, you must notify them within 30 days of their date of hire. So you've got, two different kind of potential worker populations there, the people that currently work for you, and then how do you adjust your onboarding processes going forward to make sure that you've tucked these notifications into your onboarding packets to ensure compliance there. Now that notification, and there's notifications on the website. The website's really quite helpful. It has an employer resource kind of toolkit. It has samples. It has sample notices, and so you can pull a notice. It's got the blank lines where you're going to fill in the information based on the decisions you make about what you're deducting, what your plan is, I think you got to plug in your federal employer ID number, right? There's some information that has to go into those notifications before they go to the employee. They do have to be in writing. And the law does require that employees acknowledge receipt of the communication, right? So that's an interesting little tweak that's a little bit challenging for employers, because we're not, this isn't 1980 where we sat across a desk and signed everything before as we onboarded, right? We're all doing this on mobile devices, on laptops, everything's electronic. But important to know that requirement is there. It also requires that notice be in the employee's primary language. I believe I checked this morning, and the state site only currently has those notices in English right now. I'm not sure if there's a plan to populate with additional languages, but you may just want to be ready and have those translated to the extent you need to, potentially into Spanish. If you have a strong, Spanish-speaking population, whatever population speaking non-English languages, be ready to deliver notices in a language that you expect your employees can understand. The third bullet point is about providing, obviously, to all new hires going forward. The deadline is within 30 days of hire, but obviously just tuck that into your onboarding stuff. You don't want to kick that off to have a second step 30 days out, right? Just go ahead and stick those into onboarding packets and documents that you already send to new hires as they're onboarding with your organization. Now, if the notice is going to be provided electronically, and I'm sure 99% of notices are going to be provided electronically, the employer has to provide the employee with access to an employer-owned device, the computer, during the employee's regular working hours to review and print that notice. So if the employee says they don't, if you don't have an email address for that person, if you don't have a portal or an app you're communicating with your workforce through, and don't have some way to do that, and you're only submitting it electronically, you want to make arrangements with employees who need access to your equipment and assets in order to access that. I don't expect that to be a huge issue for most employers, but it is a nuance that's written in there. And then this final point here is with regards to that receipt requirement, right? That employees have to acknowledge receipt of the communication. And as we know, getting a signature to a document is not always just as easy as it sounds, right? So if sending it out for signature, however you do that through, your HR platforms, your applicant tracking systems, however it is you push your documents for folks to sign off on, and assuming it's electronic, right? Do that. Hopefully that is captured somewhere, right? The fact that you sent it out is captured and you can prove that. If an employee refuses to acknowledge that they received that, then the employers need to be able to demonstrate how they were notified. So that's why I say you want to make sure you have a trail and some way to show that you delivered that notice to the employee. And while they may not have signed it and sent it back to you, you can at least show it was delivered. That means that you will want some kind of process around how to handle undeliverable sendouts, right? Or what happens if a week goes by, run a report, who hasn't signed, what's the reminder process going to be for this? How will we try to obtain as many signatures as possible with a safety net plan for here's how we'll prove that we sent these to folks that just did not sign and were not responsive, right? That's really the best you can do there. And then I think Melissa's going to talk a little bit about some of our posting communication requirements.
Yes, thank you, Leah. Just some clarification on the 3,700 versus the 3,900. The state still has the 2025 amount, which is the 3,700, which was 2024's wages. And they recently updated that amount to $3,900 just within the last few weeks. And they sent out in their monthly communication that update. So the $3,900 is reflective of the data that they've been collecting from wages for this year. And that rate will change every single year. So unfortunately, the state just hasn't updated that amount on the website. But if you attend any of the state webinars, they have some webinars recorded out on their website. Change. So as far as requirements, Leah touched on this, there is a written communication requirement that needs to be signed, but there's also a poster requirement. Same as all of the other poster requirements that you may have hanging in your break room or somewhere that's visible to your employees, there's a poster requirement for Minnesota paid leave as well. And this should be posted somewhere publicly where your employees can see it, or if you have employees who work remote in Minnesota, somewhere where they have access to it on whether it's in your HRIS system or an intranet, somewhere there where they can see that poster requirement. And then there's the communication piece of what needs to be included in those notices to employees. Now, great news, DEED does have the sample communication template and the poster currently available on the website. You can download that sample communication template and use that as a starting point to create your communication. But if you use that sample communication, it's going to hit all of those key pieces that you need included into the communication. And one thing to keep in mind for those of you that are on the call that are electing to go with a private plan, you have to communicate this in writing out to your employees with the same information as well. You're not exempt from it because you're going with a private plan. No matter what plan you enroll in, whether it's the state or private, you must send out these communications to any of your active current employees and then any new hires going forward. And these are the details that are required to be included in that communication. Explanation of family and medical leave benefits, including the job protection, no retaliation, continuation of benefits. The amount of premium deduction for the employer and the employee. You need to be transparent with your employees on what that share is that they're going to expect deducted from their paycheck and what the employer is covering. Information on how to file a claim. One thing about the claims process when employees are submitting information and applying for paid leave is that their cases will get approved quicker and get moved through the process if they have all of their documents ready and available at the time they're applying. And on their website, they do have some information related to what an employee may need to provide depending upon the type of leave that they're taking. Documentation from a doctor. If they're bonding with a child, they may need to provide a birth certificate. General information that supports how are they connected to the family member. If they're submitting all of that stuff all at the time they're applying, they won't get held up with the approval process. The state won't be coming back and saying, we need additional information. There also needs to be included on the form the employer name, address, employer identification number, Department of Employment and Economic Development, so deeds, mailing, address, email, and phone number, and then any other information required by deed. Like I mentioned, the sample document includes everything that DEED is expecting that the employers communicate out to their employees. So I would recommend taking a look at that, using that as a guideline for creating these communications for your employees. And then time to review your policies. I know it's end of the year. As an HR professional myself, end of the year is usually the busiest time of the season for HR professionals, but reviewing your policies, ensuring your attendance policies are not have any verbiage that would indicate that a person who is on paid leave, even if they're taking it intermittently or even using ESST, can be penalized for attendance when they're using those things. Same with FMLA, anything that's protected. Making sure your PTO and ESST policies align with paid leave. Again, you can't require an employee to use PTO, vacation, sick time, ESST, you can't require them to use those to top off those benefits. So making sure that your verbiage and your language aligns with paid leave. And if you want to allow them to supplement or top off ESST or PTO, making sure you have that included in your policy. And then reviewing your other internal leave policies, FMLA, making sure that you have it written in your FMLA policies. And just something to note for smaller businesses, if you're less than 50 employees, you're not obligated to adhere to FMLA. FMLA is for employers with 50 or more employees. But making sure that you have your policy stated that it will run concurrently with paid leave. The same with the Minnesota pregnancy and parental leave law. I mentioned earlier that under the Minnesota pregnancy and parental leave law, your job is protected on day one of employment if you need to go out for having a baby or anything related to parental leave while bonding with a child. So making sure that you have language that state law will run concurrently with Minnesota paid leave. Looking at your short-term disability and salary continuations and any parental leave policies that you have in play, because again, those benefits cannot be an option for the employee to choose over Minnesota paid leave. They can supplement and top off the Minnesota paid leave. And then big thing, if you haven't done it already, if you're enrolled in the Minnesota unemployment insurance website, you need to go out to that website to assign a paid leave administrator. If you haven't signed up for Minnesota unemployment, you need to get enrolled in that. And then you'll be able to assign a paid leave administrator. You can sign up as many paid leave administrators as your company would choose to have enrolled in this program. That person is going to be the individual that's going to be responding to any of the claims that come through, similar to unemployment. Again, employers do not make a decision if a leave is approved or denied. That is out of all of our control. Unlike FMLA, we get to decide whether or not something's approved. We can ask for additional information. We just get notified if the person is approved or they're not approved. One thing to keep in mind and make sure you write in your policies is what type of notification requirement you want from your employees. So we talked about best practices, typically that 30 days, but that is going to be a key question that the state is going to ask in the application process back to the employer is, did the employee notify you first? Now, there is a potential that if they didn't, that the state could deny that person's claim or at a minimum, pause that claim approval process and send it back to the employee and say, you need to communicate with your employer that you are going to be taking this leave before this will be approved. So again, making sure it's important that you have language updated in your policies regarding the notification of paid leave. Create a process for handling leave. So HR teams, how you want to be notified, what your expectations are of that. And then there is a time frame in which the state is going to expect employers to respond to the questionnaires and making sure that you have someone that's going to be staying on top of that regularly. And then determining how you will handle benefits in arrears. Again, employees not getting a paycheck from you, but you have to keep those benefits at play, how you want to collect on those benefit premiums that the employee is receiving while they're out. And then train your managers and your staff, making sure that they understand how to handle this, what the expectations are, what the policy changes are. Hopefully, most of you are already been digging into this topic and you're not going to be scrambling at the end of the year. But I feel your pain. I'm right there with you. And good luck to everybody as we ramp up for 2026 and this change in everything related to Minnesota state law and how we handle leaves.
Yeah, and I think I'll just quickly hit on rest breaks and meal breaks because we're like an infomercial, guys. There's more. It's going to feel like a breeze. Rest breaks and meal breaks have been redefined for 2026 in Minnesota, right? And it's in the past has been a sufficient amount of time to allow for those breaks and had some parameters. Starting January 1, 2026, be aware that all of your non-exempt employees are going to be entitled to a 30-minute meal break if and when they're working 6 consecutive hours or more. And then rest breaks of 15 minutes paid every 4 consecutive hours of work. So this is very important. And I say it's easy. It's going to feel easy. I know it's not. I'm completely joking. These really are very important. And I would just caution everyone to look at California as an example where we see this exact type of structure with regards to the timing of breaks, the requirements, paid, unpaid. And these are very, very susceptible to class actions. So employers under this law are required to allow this time. You don't have to mandate it, which is a little bit helpful because in some states they require the employers to ensure that the employees take those break periods. Whereas in Minnesota, you have to allow the employees to take that time. And you can develop a process through which employees can waive these breaks, but it needs to be in writing. You need to be able to prove it. The burden of proving it will be upon the employer. And so you want to make sure you develop that process now to have that in real time, capturing if and when someone is planning to waive or didn't take an otherwise provided meal or rest break period. And just in terms of really quick best practices on this subject, one, do not auto deduct 30 minutes of unpaid time from every paycheck to allow for this meal period. It's for anyone who works more than 6 consecutive hours. I know administratively it's simpler, but it facilitates a lot of legal risk and is very, very challenging. Don't round time. Rounding up, rounding down can be very high risk, and you have to round up with the same frequency you round down. And since that will never match up 50-50, every employer will be out of compliance in terms of rounding. So want to be very careful with rounding time policies. And then employers would be encouraged to open up a mechanism through which employees can report if and when they had to work part of their unpaid meal period, or had to come back early, or took it late, or something along those lines, and then you can decide how you will proactively address and remedy those, because there is a penalty structure under the law that they're entitled to payment times 2, and you want to be able to issue that payment sooner rather than later to avoid penalties on delayed wages. So anytime something touches wage and hour compliance, we do want to try to aim for as much compliance as possible due to the high risk of class action and the fact that 99.9% of your insurance policies will not insure those claims. So they can be not only expensive and time consuming, but also uninsured. And it's kind of the trifecta of painful. So be cognizant of that. And then just quickly, of course, minimum wage increases for folks to know that, as always, January 1 presents that opportunity as well.
Well, so do apologize because we have run out of time here. There were a lot of wonderful questions. In particular, there are a lot of questions that pertain to, this is how we're doing it. Is this compliant? Is this not? Certainly need to encourage anyone with questions like that to seek the inside or outside legal counsel, because there are going to be a lot of nuances to how your general practice has been, what it looks like, and certainly want to get ahead of that prior to this upcoming year here, because the time is starting to run out. So there's one question I'll pose as we wrap this up. Will the state notify employers when an employee requests paid leave through the state portal, and will we have the opportunity to respond in some manner?
Yes. Yes, the state will notify you. So it's important that you go out to the Minnesota unemployment website, assign that administrator for your paid leave plan. That person will get notified, and then they will be required, I believe it's 7 days that the employer has to respond. So once the application opens, very similar, if you're familiar with the unemployment process, you will have to fill out a statement as the employer, and then the state will make the decision. We do have a QR code on the landing page that links you right directly to Minnesota Deed. They have lots and lots of amazing tools. I highly encourage that you attend any of the upcoming state offered in-person seminars that they have, or any of their virtual seminars. They're very helpful. And they have a preview of the actual portal, and you can see what it looks like.
Well, so with that, I want to conclude this by saying thank you so much for attending. The recording of the webinar will be available after the conclusion of this event. We'll be sending that around. And with that, as we move into this upcoming calendar year and well beyond, if ever there's an opportunity to continue to expand our partnership and whatever it looks like to help supplement any leave, please let us know. And pleasure doing business with most of all of you. And good luck as it relates to building out these policies heading into 2026. So thank you for everything.